Something happened at the Supreme Court that almost nobody saw coming, and now legal experts are warning that the effects could spread across all 50 states. This wasn't a narrow ruling, it wasn't a temporary order, and it definitely wasn't a divided court struggling to reach agreement. It was unanimous, 9-0. Every justice on the Supreme Court reached the same conclusion, and when all 9 justices agree on something involving constitutional rights, government authority, and federal law, the country pays attention, because unanimous rulings like this don't happen often, especially on issues tied to national policy. But what's making this decision even more important is the growing belief that it could permanently reshape how major laws are interpreted and enforced in America. Not just in one state, not just in a few federal districts, all 50 states. That's why attorneys, lawmakers, agencies, and millions of ordinary Americans are now trying to understand what exactly changed. Because the ruling itself didn't come with dramatic language. There was no nationwide announcement declaring an immediate ban or a massive new federal mandate. Instead, the court did something more powerful. It changed the legal framework. And when the legal framework changes, the effects spread far beyond a single case. To understand why this matters so much, you have to understand how the federal government works when it comes to regulations. Congress passes laws, but federal agencies often decide how those laws are applied. They interpret language. They create enforcement standards. They issue regulations based on what they believe the law allows. And over time, those interpretations can become extremely influential. Sometimes they affect millions of people, sometimes entire industries, and sometimes constitutional rights themselves. For years, critics argued that federal agencies had too much power, that unelected officials were effectively creating national policy without Congress directly approving every major change. Supporters of agencies disagreed. They argued that modern government requires flexibility, that agencies need room to respond to new technologies, evolving problems, and changing national conditions. That debate has existed quietly for decades, but eventually, one legal challenge brought the issue directly to the Supreme Court. And now the court has answered in a way that may change America permanently. The justices ruled unanimously that federal agencies cannot make major policy decisions unless Congress clearly authorized them to do so. Not implied authority, not broad assumptions, not vague interpretations expanded over time. Clear authorization. That principle is now at the center of the ruling. And while it may sound technical at first, the implications are enormous, because many federal regulations across multiple industries rely heavily on agency interpretation. Environmental rules, healthcare mandates, financial oversight, energy policies, and yes, firearm regulations too. That's why experts are saying all 50 states could be affected, because this ruling doesn't target one local issue. It changes how federal authority itself is evaluated nationwide. Already, attorneys across the country are reviewing existing regulations and asking one question. Did Congress clearly authorize this? Or did agencies stretch the law beyond what lawmakers originally intended? If courts begin applying this new standard aggressively, some regulations could face serious legal challenges, and that possibility is sending shockwaves through the legal system. Now, one of the reasons this ruling is causing such intense reaction is because of how broad the court's reasoning appears to be. The justices didn't focus narrowly on one specific policy area. Instead, they addressed a much larger constitutional issue. Who gets to make major national decisions? Congress or federal agencies? And according to the court, if the issue is significant enough, Congress must speak clearly. That changes the balance of power in Washington, maybe dramatically. Because for decades, agencies often relied on broad congressional language to justify major rules. Now, courts may demand much more specific authorization. That creates a whole new legal environment, one where agencies may become more cautious, one where Congress may face more pressure to write detailed legislation, and one where courts may gain greater influence over determining what agencies can and cannot do. That shift affects the entire country, not gradually over generations, immediately. Because every federal agency now understands that future regulations could face tougher constitutional scrutiny. Now, reactions outside the courtroom have been intense. Some legal scholars are calling this one of the most important administrative law rulings in modern history. Others say it represents a major correction to what they viewed as decades of expanding agency power. Advocacy groups on both sides are responding quickly. Supporters of limited government authority are celebrating the decision. They argue that it restores constitutional balance and protects Americans from unelected bureaucracies creating major national policies on their own. Meanwhile, critics of the ruling are deeply concerned. They warn that limiting agency authority could make it harder for the government to respond quickly to emerging national problems. They argue that Congress often moves slowly and struggles to adapt to rapidly changing conditions. Without flexible agencies, they fear regulatory gaps could emerge across critical industries. Both sides agree on one thing, though. This ruling matters a lot. Because the Supreme Court didn't simply settle one dispute. It established a constitutional principle that lower courts must now apply nationwide. And once that process begins, the legal consequences can spread quickly. Already, federal agencies are reviewing internal policies. Lawyers are studying every word of the ruling. And lawmakers are beginning to feel pressure to respond. Because if agencies now face stricter constitutional limits, Congress may need to step in more directly moving forward. That could reshape how laws are written in America. More detailed legislation, more precise language, less reliance on agency interpretation. But achieving that kind of legislative clarity is not easy. Congress is deeply divided on many major issues, and writing highly detailed national laws often takes years. That means courts may continue playing a larger role while lawmakers struggle to adapt. Another major issue is how lower courts will interpret this ruling. Some judges may apply the standard narrowly. Others may apply it broadly. That could create legal differences across regions of the country. One federal appeals court may strike down a regulation. Another may uphold a similar one. And when courts split like that, the Supreme Court often steps in again later to resolve the disagreement. Which means this unanimous decision may only be the beginning of a much larger legal transformation. Now, here's something many Americans are only beginning to realize. This ruling could affect ordinary life in ways that go far beyond politics, because regulations influence daily life constantly. Energy costs, healthcare systems, business compliance rules, consumer protections, environmental standards, transportation requirements. Federal agencies touch nearly every part of modern society, and if the constitutional rules governing those agencies change, the effects eventually spread outward into the real world. That's why analysts say the ruling may reshape America for years to come, not through one dramatic overnight event, but through hundreds of smaller legal changes over time, case by case, policy by policy, court by court, until eventually, the entire regulatory system begins operating differently, and that process has already started. Now, another reason the unanimous vote matters so much is because it sends a strong message to lower courts. A divided ruling can leave room for uncertainty, but a 9-0 decision tells judges nationwide that the Supreme Court sees the constitutional issue as fundamentally clear. That level of agreement carries enormous weight, especially in future litigation. Attorneys challenging federal regulations will now point directly to this ruling as constitutional support, and judges will have to take those arguments seriously. That's why legal experts believe new lawsuits could appear quickly across multiple industries, not just firearms, not just environmental law, potentially everywhere agency authority is involved. At the same time, federal agencies may begin adjusting their behavior preemptively. Officials may hesitate before issuing aggressive new interpretations of existing laws. They may seek stronger congressional backing before expanding regulations. And that caution itself could change how the federal government operates moving forward. This is what makes the ruling so historically significant. It's not simply about one law. It's about the structure of power itself. Who decides national policy, how those decisions are justified, and what constitutional limits exist when government authority expands. Those are foundational questions, and the Supreme Court just answered them unanimously. Now, for ordinary Americans trying to follow all this, the legal language can feel overwhelming. But the core issue is actually simple. The court is saying major national decisions should come directly from elected lawmakers whenever possible, not primarily from agencies interpreting vague laws broadly over time. That principle may sound abstract, but its effects are concrete, because it changes how future regulations may survive in court. And that means the legal landscape across America is now shifting, quietly in some places, dramatically in others, but shifting nonetheless. As more lawsuits emerge, as lower courts begin applying the ruling, and as Congress and federal agencies respond, the full impact will become clearer. But today, one thing is already obvious. This unanimous Supreme Court decision did not simply resolve a legal argument. It opened a new chapter in how America governs itself, and that chapter could affect every state in the nation for years to come. Now, as the country begins absorbing the full meaning of this unanimous Supreme Court decision, the next phase is already unfolding. And this is where the real consequences may become impossible to ignore. Because once the Supreme Court changes the constitutional framework around federal authority, every part of the legal system has to respond. Lower courts, federal agencies, Congress, state governments, and eventually, ordinary Americans themselves. That process has already started. Quietly at first, but the effects are growing larger every day. Right now, attorneys across the country are preparing new legal challenges based directly on this ruling. They're identifying federal regulations they believe may no longer survive under the Supreme Court's new standard, and they're asking the same question again and again. Did Congress clearly authorize this? Or did a federal agency expand its authority beyond what lawmakers actually approved? That question is now becoming central to courtrooms nationwide. Because the Supreme Court made something very clear. Major national policies cannot rest on vague interpretations alone. The authority must come directly and clearly from Congress itself. That sounds simple, but applying it in practice could become extremely complicated. Because for decades, federal agencies have relied heavily on broad congressional language to regulate modern problems, new technologies, new industries, new safety concerns, new environmental issues, new financial systems. Congress often writes laws in broad terms, then agencies fill in the details later. That system became standard across much of the federal government. But now, the Supreme Court has signaled that there are constitutional limits to how far that process can go, and that changes everything. Because once courts begin enforcing stricter limits on agency interpretation, entire regulatory systems may face new pressure, not just in Washington, across all 50 states. Now, one of the biggest concerns among legal analysts is inconsistency. Different federal courts may interpret this ruling differently. Some judges may apply the decision very broadly, striking down regulations they believe exceeded agency authority. Others may apply it cautiously and narrowly, preserving existing policies unless Congress clearly failed to authorize them. That could create legal confusion nationwide. In one region, a regulation may remain fully enforceable. In another, a similar rule may be blocked. And when federal courts split like that, pressure builds quickly for the Supreme Court to step in again, which means this ruling may not be the final word. It may only be the beginning of a much larger legal transformation. Now, outside the courtroom, federal agencies are already responding behind closed doors. Internal legal teams are reviewing existing regulations carefully. Officials are analyzing which policies may be vulnerable under this new constitutional framework. And perhaps most importantly, agencies are asking themselves how future regulations should be written moving forward, because the old approach may no longer work the same way. Broad interpretations now carry greater legal risk, and that risk changes behavior. Agencies may become more cautious, more restrained, more dependent on direct congressional approval before issuing major new rules. That shift alone could permanently change how the federal government operates. But here's where the situation becomes even more significant. Congress itself may now face enormous pressure. Because if agencies lose flexibility, lawmakers may need to act more directly. That means more detailed legislation, more specific language, and more political battles inside Washington. The problem is, Congress has struggled for years to pass major legislation quickly. Debates become gridlocked, compromise becomes difficult, and highly technical issues often move slowly through the legislative process. Federal agencies once filled that gap by interpreting broad laws to address evolving situations. But if courts now limit that flexibility, Congress may inherit much more responsibility than before, and that could reshape the balance of power in American government itself. Now, this is one reason legal scholars are calling the ruling historic, not simply because of the immediate policy effects, but because of the structural impact. The Supreme Court may have fundamentally altered how federal power is exercised in the United States. That's why the decision is being discussed far beyond legal circles. Businesses are watching, state governments are watching, industry groups are watching, because regulations influence almost every part of modern life. Energy production, healthcare systems, banking rules, transportation standards, consumer protections, environmental compliance. All of these areas involve federal agencies interpreting laws, and if the constitutional rules governing those interpretations change, the effects can spread almost everywhere. Now, politically, reactions remain deeply divided. Supporters of the ruling argue that it restores constitutional accountability. They believe Congress, not unelected agencies, should make major national decisions. They say Americans deserve laws written directly by elected representatives, not policies created through administrative interpretation. Critics strongly disagree. They argue that modern government is too complex for Congress alone to manage every technical issue directly. They warn that limiting agencies too much could weaken the government's ability to respond quickly to national problems, environmental emergencies, financial crises, emerging technologies, public safety concerns. According to critics, agencies exist precisely because modern society changes faster than Congress often can. That debate is now becoming even more intense because of this ruling, and it may shape American politics for years to come. Now, another major question is how state governments may respond. Some states may attempt to create stronger local regulations in areas where federal authority becomes uncertain. Others may move toward reducing regulations, believing the ruling supports a narrower view of government power overall. That could increase legal differences between states even further. And for businesses operating nationally, that creates serious complications. Because inconsistent rules across states often increase legal uncertainty and compliance costs. That's why many industries are watching this case so carefully, not because they're focused on one specific policy, but because they understand what happens when constitutional standards around regulation suddenly shift. The entire system becomes less predictable, at least temporarily. Now, another important detail is the message this ruling sends about the Supreme Court itself. A unanimous 9-0 decision carries enormous symbolic weight. It signals strong institutional confidence. It tells lower courts that the constitutional issue is not viewed as a close call. That level of agreement matters because it influences how aggressively future judges may apply the ruling. Lower courts tend to move cautiously when the Supreme Court is divided, but unanimous decisions often encourage stronger enforcement of the court's reasoning. That's why many experts expect this ruling to become one of the most cited administrative law decisions in future litigation, and the ripple effects could continue for decades. Now, for ordinary Americans, the full legal complexity may feel difficult to follow. But the practical reality is simpler than it seems. The Supreme Court has made it harder for federal agencies to create major national policies without clear congressional approval. That principle may sound technical, but it affects how government authority works across the entire country. And over time, it could change how regulations are created, enforced, challenged, and defended. That's why this story matters so much. Not because everything changes overnight, but because the constitutional foundation beneath the regulatory system has shifted. And when foundations shift, the effects spread slowly but powerfully through everything built on top of them. That process is already underway. New lawsuits are coming, new court battles are coming, new political fights are coming, and eventually the Supreme Court itself may revisit these issues again as lower courts interpret the ruling differently. Because major constitutional transformations rarely happen in one moment alone. They happen through a series of decisions that gradually reshape the system over time. This may be one of those moments, one of those turning points that future historians look back on and say, that's when the balance started changing. That's when the legal framework shifted. That's when America entered a new phase of constitutional governance. Right now, we are still in the early stages. Questions still outnumber answers. Courts are still adjusting. Agencies are still reacting. And lawmakers are still deciding how to respond. But one thing is already undeniable. This unanimous Supreme Court ruling has shaken the legal and political landscape across all 50 states. And the consequences may continue unfolding long after today's headlines disappear.